beautiful ladies.
Hello.
This is Usha Tandon.
Hello, hello. Wonderful
Faculty.
meeting you.
So all ladies are leading here, yeah?
I know.
The women power right now, is it?
Discipline power.
कल जा देखना जैसे सर ज्वाइन करेंगे बताना।
जी सर।
बाजपेयी सर ने ज्वाइन कर लिया?
जी सर, जी सर।
सर नमस्कार सर।
So Dr. Mishra, if I am not able to put on my PPT, I hope you can put that on.
अजय जरा मैम की पीपीटी जरा अपलोड कराओ।
So let me try. I'll try, but I'm not promising.
You can always send it to the organizers. They will help you out in this.
Yes, I've already sent it.
Okay. Then they will take care. Then you need not, play it. They will be playing it for you.
Ma'am, Ajay will play, ma'am. No issue, ma'am. Ajay will do.
So let me try. I cannot claim disability all the time. Let me try.
Your name is very familiar with one of our colleagues, Usha Ramanathan.
Oh, yeah. A lot of people ask me whether I am Usha Ramanathan or something else. And
she is also more an activist.
Yeah.
More lawyer, but more into all this social cause work, etc. So we are waiting now for how many speakers? Dr. Ashok, I think only Baghel sir has to join. Or
yes, ma'am. Yes,
Dr. Mani also.
No. Dr. Mani sir have joined, ma'am.
Okay.
Dr. Rajiv Mani sir have joined.
Okay, sir. Then it is only
Baghel sir.
As a Baghel sir only. Fine.
Ma'am, I think we can start the moment sir will join. We can.
Fine. What's the time right now? Exact time?
3:47, ma'am.
Oh, yeah. But what is the news on his side? वो join कर रहे हैं या?
मैम वो join कर रहे हैं. उनके PS का फोन आया हुआ है. वो कह रहे हैं कि सर इज joining. Basically he is in Agra. तो वो कह रहे हैं कि सर अभी ज्वाइन कर रहे हैं. तो मैम मुझे लग रहा है कि हम लोग स्टार्ट करते हैं और जैसे ही सर ज्वाइन करेंगे फिर से हम लोग उनका मतलब इंट्रोडक्शन बीच में दे दिया जाएगा. फिर आप मैम कर लीजिए.
ठीक है.
अजय जरा देखते रहना. जैसे सर ज्वाइन करेंगे एक बार इंटीमेट करना. ठीक है.
राइट सर. यस.
या उनके पीएस के उससे आएगा आईडी से.
ओके.
उनके ऑफिस में कनेक्ट कर लिया है? Has his office connected us? Okay.
No, ma'am. No.
Good evening, Dr. Rajiv Mani.
Good evening, madam. How are you?
Good. Very.
And good evening to all the participants of this meeting.
Good evening. Good evening.
Yes.
अब स्टार्ट करा लें हम लोग. फिर कुशाल स्टार्ट करो.
Yes.
Okay, sir. Good afternoon to one and all. I, Kushal Garg, on behalf of the organizing committee, takes pride to introduce the distinguished panel of speakers for this 9th session of this international conference titled Mediation Bill, Its Prospects. As the chief guest of this session, we have with us Honorable Professor Satyapal Singh Begal, Minister of State in the Ministry of Law and Justice. Then we have Shri Sujit Kumar Bajpayee, Joint Secretary, Ministry of Environment, Forest and Climate Change, Government of India. Shri Sujit Kumar Bajpayee is presently serving as a Joint Secretary in the Ministry of Environment, Forest and Climate Change, Government of India. He was previously working as a Deputy General Manager, Environment in the National Hydroelectric Power Corporation. Sir holds a PhD in Environmental Science from Jawaharlal Nehru University. We are delighted to have you, sir, as a chief guest, as a special guest. Then we have with us Dr. Rajiv Mani, Additional Secretary, Ministry of Law and Justice, Government of India. As a special guest, Dr. Mani is closely associated in carrying forward the legislative initiatives of the Government of India in strengthening the ease of doing business environment and in efforts to promote institutional arbitration and making India a hub of international commercial arbitration and developing an ADR ecosystem. Sir has dealt with proposals of legislative reforms to facilitate fast-track adjudication of commercial disputes. Sir is also a member of core committee in connection with implementation of draft rules for reception, retrieval, authentication and preservation of electronic records in the Indian courts. Sir was a guest faculty in Bureau of Parliamentary Studies and Training and has regularly given lectures on various subject matters. We are delighted to have you, sir, as a special guest. Then we have Ms. Laila Ollapally, mediator and a member of International Mediation Institution, as our special guest. Ma'am is the founder of CAM, Arbitration and Mediation Practice Private Limited, a pioneering private mediation initiative that seeks to promote mediation as a form of alternative dispute resolution in India. She's also a founding coordinator of Bangalore Mediation Center, Court Annexed Mediation Program of the High Courts of Karnataka, one of the leading court annexed mediation programs in the country. She's a senior mediator and a master trainer at BMC. Ma'am is on the panel of mediators of the Singapore International Mediation Center and has been appointed on their users council. She's on the advisory board of Global Mediation Panel, UNDP, and FSRI. She was a member of the committee constituted by the Mediation and Conciliation Project Committee, MCPC of the Supreme Court of India, to work on draft of the legislation for mediation in India. We are delighted to have you, ma'am, as a special guest. Then we have, and lastly, we have Ms. Uma Ramanathan as our special guest. Ma'am was trained as a mediator by Geeta Ravindran, trainer from Virginia, USA, and is also a certified commercial mediator by JMAS. She has trained advocates as mediators in many parts of India in the programs organized by MCPC, Supreme Court of India, and orientation programs on mediation in National Judicial Academies and in the Judicial Academy, Tamil Nadu, for referral of judges. Ma'am has been the organizing secretary of Tamil Nadu Mediation and Conciliation Center, High Court of Madras since 2010, and is a member of panel of mediators and judges who drafted the Mediation Training Manual of India as an initiative of the Mediation and Conciliation Project Committee, Supreme Court of India. Ma'am has also presented various research papers in the plethora of national and regional conferences on mediation. Without taking much time, I would like to call Professor Usha Tandon, Dean and Head Faculty of Law, University of Delhi, who will be moderating this session. Over to you, ma'am.
Thank you, Kushal. Well, I'm delighted to welcome the chief guest in absentia. Hope he's joining us soon. Honorable Professor Baghel, and then the guest of honors, Dr. Rajiv Mani, Additional Secretary, Ministry of Law and Justice, Government of India, Ms. Laila Ollapally, Mediator and member of International Mediation Institute, Shri Sujit Kumar Bajpayee, Joint Secretary, Ministry of Environment, Forest, Climate Change and Government of India, and Kumar Ramanathan, mediator and trustee of FCPF, that is Foundation for Comprehensive Dispute Resolution. Well, as we know that this particular session is on that mediation bill that has been introduced in the Parliament hardly 4 months before. As a matter of fact, right from the inaugural session of this particular conference, we have been hearing something or the other about the mediation bill. But this is the session wherein it is, the whole session is exclusively dedicated to none else than the various provisions and the prospects and the challenges, whatever provisions are contained there in the mediation bill. Well, I may take this opportunity to welcome all those participants who are connected with us at this particular moment, and those who have read the bill or even has seen the bill must have realized this thing, that it's a quite comprehensive piece of paper, which has as many as 65 sections, which are spread into 11 chapters, and then there are 9 schedules of it. If I just talk about the first thing, that is a preamble of this particular bill, it talks about 4 or 5 things. The first thing is very simple and natural when it says facilitate and promote the mediation, but with special reference to institutional mediation. The second is the consequent of the first, that is, if we have to promote it, then how to take care of that enforcement part of it. So it talks about, the preamble also talks about the enforcement of the mediated settlement. Then the third thing I think perhaps is quite remarkable about this bill, which lays down or prescribes a regulatory authority, that is the Mediation Council, as we have been talking about on that. The fourth and fifth things which are highlighted here in this particular part, the preamble, relate to the encouragement of, number one, community mediation, and the another, online mediation. So we can find that the various provisions are there to give effect to these 5 core principles which are mentioned there in the preamble. But then there are certain contentious sections which have been talked about, section 6, section 20, section 25, so on and so forth. So we are really keen to listen our distinguished speakers on whatever part or portion aspect they have chosen to speak on in this particular session. So with these words, may I invite Shri Sujit Kumar Bajpayee, Joint Secretary, Ministry of Environment, Forest and Climate Change, to address the audience, please. Mr. Bajpayee.
Yeah, am I audible, ma'am?
Yeah. Yes, very much.
Yeah.
Yes.
So thanks a lot for having me here, and I wish to compliment the organizers for organizing such a important conference on such an important topic. Nothing can be better than time, because once bill has been introduced in the parliament, so discussion must go on. And as far as environment is concerned, nullifies that anything which is being considered by NGT. So it will be out of the purview of this bill. But still, I would like to talk about it, because I firmly believe that many of the sections and many of the aspects which this bill covers, gradually, slowly, steadily, definitely, I believe that it will bring many of the environmental disputes also in the ambit of this bill. So, pardon me, actually, I'm outstation, so I'll be, there's connectivity issue also here in Port Blair. So I'll be switching off my video so that the connectivity remains constant as far as audio is concerned. See, the notion that I'm just quoting one of the statements excerpt from the Justice Warren Burgess address in 1976, where he said that the notion that ordinary people want black-robed judges, well-dressed lawyers, and fine paneled courtrooms as a setting to resolve their dispute is not correct. People with problems, like people with pain, want relief, and they want it as quickly and inexpensively as possible. And they want alternatives to the adversarial process of litigation that reduces crowded court dockets and is more efficient, less formal, less expensive, less stressful, and which takes less time than that the traditional system takes. So this can be, effortlessly applied to the concept of mediation as a method of alternative dispute resolution mechanism. I call it appropriate method, appropriate dispute resolution mechanism rather than alternative.
Yeah.
And it has been now accepted all around the globe as an effective, as you all know, expeditious and economical alternative to litigation. If I talk about the context in an Indian context, so books of law, ancient, and deep-rooted in India, from Lord Krishna mediating between Kauravas and Pandavas in the Mahabharata, to family elders resolving domestic disputes, to the resolution of disputes at the community level through panchayat. So there exists a strong culture of mediation as far as India is concerned. And with the passage of time, as we all know, that there have been certain statutes which provides for mediation as a mode of settlement of disputes between the parties. India has also a signatory to the Singapore Mediation Convention, and which gives mediation settlements the force of law. However, as we all know that because of a lot of discrepancies and confusion regarding applicability of these laws, has led to a need of a creation of a uniform legislation concerning mediation to create legal sanctity and avoid the inconsistencies between the various pieces of existing legislation. As we all know that although even though these various statutes, they have given the parties to the kind of autonomy to get their disputes resolved via mediation, and there exists court referred as well as private means of engaging in mediation, there is still a lack of procedural guidance in this regard. So I believe that with this intent and to promote and facilitate mediation, especially institutional mediation for resolution of disputes, commercial or otherwise, enforce mediated settlement agreements, provide for a body for registration of mediators to encourage community mediation. See, if I consider the mediation in environmental matters, because I'll be talking about environmental issues only, it's common practice for mediators to practice activist mediation, which operates differently from traditional stance of neutrality. And the responsibility of the mediator and thus in general environmental mediation seems to be kind of hybrid of public participation method. So hence, I mean, it's not an easy task to initiate mediation proceedings in environmental matters, and as a result has limited applicability. But if we see the environmental impact assessment notice, it has inbuilt public consultation engagement where the community engages with the project proponents, and they kind of negotiate as far as their issues are concerned. But again, I'll say that going forward, if we see the chapter 10 of the mediation bill, going forward, I think gradually this public consultation can be effectively addressed through this community mediation as prescribed in the mediation bill. Because the existing system of public consultation, where the public just comes and they speak their voice, it may or may not be addressed. And we have seen many instances in countries where big projects have got stalled because there is no communication, effective communication between the two parties. So in that context, it becomes very, very important that gradually and steadily this community mediation finds place in the environmental settlement, environmental mediation. So I know it's very complex, because there are a lot of impediments in this process, because the scientific and technical complexity of the issues. And normally issues do not affect the ideological, structural, technological, organizational. Also, these disputes also involve adequate infrastructure capacities and adequate awareness. That is why the promulgation of the bill in itself is the way forward in formalizing. I conclude my hope that this bill finally see the light of the day, and it becomes
So there is connectivity, ma'am. There is connectivity issue.
more
I can
effective
invite other
as we
speaker
go.
also.
He's going to be reconnected.
Yeah, I have finished. I have finished. Thank you. Thank you.
Thank you, sir.
Okay. So it's over from his side. It's confirmed now, Dr. Ashutosh.
Just joining, ma'am. No issue, ma'am. We can go ahead. He will
Yeah.
just join.
So Mr. Bajpayee, I hope you are able to hear us.
Are you? Yes, yes, I can.
Yeah. So thank you very much for sharing your thoughts on some of the aspects relating to this mediation bill, though you did not specifically talked about the provisions, but did talk about certain things relating to the community mediation with reference to the environmental disputes. I hope your work must be going on to examine whatever community provisions are there in our mediation bill. There are only 2 sections which are devoted to the this community mediation. To what extent they can really take care of environmental disputes, which really go beyond merely the public hearings. So we are looking forward some writings or some other speech from you analyzing the provisions from the point of view of whatever your concerns are there. Thank you very much for your presentation. So now let's move forward to our other speaker.
Ma'am, Honorable Minister sir have joined, ma'am.
Okay, fine. That's wonderful. We have been waiting for him. I couldn't see here on the screen. Okay.
Professor,
Yes.
Dr. Mishra, can I leave my screen on my slide on the screen? Is it okay?
Yes, yes. No, I think let us have it when it is your presentation for a time being. Baghel sir, very warm welcome to this conference, sir. We are really delighted to, welcome you as the chief guest of this particular session, which is on the mediation bill, which has been introduced in the parliament just 4 months before. So we are indeed honored to have Honorable Professor Satyapal Singh Baghel with us, who is currently the Union Minister of State, Ministry of Law and Justice. He has served as a member of parliament thrice in 1998, 1999 and 2004, and in the Rajya Sabha in 2010. And we really look forward for very fruitful insights from your side, sir, as a chief guest of this particular session. Thank you very much, sir, for joining us. So we proceed further. It is only one of the speaker who has just spoken. So with your permission, should we, carry on further, and should I, sir, we invite the other speaker of the session? Yes, I think we can have Miss Laila Ollapally itself, because she has been preparing for working on the slides for long, and ultimately she has been able to set it right. So let us have Miss Laila to make her presentation. Please go ahead. Am I audible?
Yes, yes, you are. Can you hear me?
Yes, yes. Yeah, please go ahead.
I must first confess that I am technologically challenged. So anything I overstep by, by way of putting the slide earlier and all that, please pardon me. It's just getting used to this whole technology of showing a PPT. Anyway, I'm grateful to be with all of you and to be addressing a topic like this, which I think is very close to all our hearts. Mediation is the only dispute resolution process that is based on bringing disagreeing parties to be able to speak to each other, to collaborate, to create value. And this kind of a process is being given legal sanctity through this bill. It is standing shoulder to shoulder now with the adversarial processes, where parties are fighting each other, is standing shoulder to shoulder with arbitration and litigation. So this is heartbreaking. I will be presenting the beneficial provisions and the impact, and the other part is provisions of concern and the impact. So let's talk about the beneficial provisions. First, institutional mediation, as Dr. Usha Tandon just mentioned, the preamble itself says this bill is to promote and facilitate mediation, especially institutional mediation. This is really throwing light on one more aspect of mediation. Till now, we had court annex programs, court annex mediation, pro bono mediation. And now focus has expanded to institutional mediation also, which means institutions governed by rules, code of conduct, best practices, panel of mediators, a choice of mediators to parties. So this will really expand and support the growth of mediation. The analogy could be that of government hospitals and private hospitals. We need both, but to invite different sectors of the users, to invite higher degrees of skill practicing the process. Mediation in institutions will add to it. Second beneficial provision, government disputes can be mediated. Commercial disputes of the government. Also, if there are any other disputes, then state governments and central government can form guidelines to mediate those disputes. This is really going to improve the administrative and legal efficiency in our country. Of course, these settlements have to be agreed to by somebody who's a competent authority, and these decisions that are bona fide is protected. This will greatly enhance the efficiency of the administration of the courts and also ease of doing business. Third, it protects the basic tenets and enforceability of mediation. Basic tenets is self-determination, voluntariness, confidentiality. When these tenets of mediation are protected, then parties are confident to use the process. The bill is protecting these tenets, making it watertight. Therefore, the process of mediation gains credibility and acceptability. My only point is, in certain provisions of confidentiality, section 23.2 and 23.4, we need to focus a little more, because the definition grants confidentiality, admissibility, and privilege against disclosure to parties, participants, and mediators. It has to be a catch-all, but I think it was oversight. In section 23 and 24, it lacks a little more fine-tuning to catch all three and protect confidentiality and admissibility and privilege against disclosure. So maybe a little there, and we have a perfect basic tenets of the mediation protected by this bill. Enforceability, a mediated settlement agreement can be executed like a judgment or decree of the court. All this is really going to give confidence to the users of mediation. Next, mandatory pre-litigation mediation, much talked about. Why this is important? Mediation is so different to all the other dispute resolution processes. The default response of parties in dispute is adversarial. And therefore, when we try to explain what mediation is to a party caught in litigation or caught in dispute, it's very difficult for them to even comprehend it. Therefore, if there are 2 sessions of mandatory pre-litigation mediation, they get an opportunity to experience mediation, and the mandatory they can then convert to voluntary. Italian experience with mandatory pre-litigation mediation shows that 50% of these mandatory pre-litigation mediation cases, 50% convert into voluntary mediation, and out of that, 25% resolve. Important element here is when the parties go in for mandatory pre-litigation mediation, who the mediator is very important. If the mediator is skilled, the mediator can quickly convert the mandatory into voluntary. Parties will opt to go into the voluntary process. But if it is a negative experience, then we are just adding some more burden to an already burdened litigant. So who the mediator is very important in mandatory pre-litigation mediation. These are the beneficial provisions that I thought is important. Not that it is only this, there are many more. Due to paucity of time, I'm mentioning these. The next slide is provisions of concern and the impact. My provision of concern is again mandatory pre-litigation mediation. Although it is beneficial, as I mentioned, if the mediator does not have the skills, it becomes a burden to the parties. Therefore, capacity issues are something that we should be aware of. Do we have enough mediators to handle pre-litigation mediation in all civil disputes, or maybe just in some specific areas? My other concern on this is commercial disputes are not benefiting. Section 6 says that commercial disputes.
Slide dikha rahe hain.
Is there a problem? Am I okay? Dr. Usha, you're muted.
Yeah, please go ahead.
Okay.
Please go ahead. Yeah.
Okay. The commercial disputes, pre-litigation mandatory mediation in commercial disputes is covered by the by section 12A of the legislation applicable to the what is it? The corporate. What is it? Which sector is it? Uma, just help me with that. 12A. 12A of the Commercial Codes Act. Yes, sorry. It comes under the 12A of the Commercial Codes Act. Now, Commercial Codes Act is a prior legislation. We have seen that it has many pitfalls, and that is not as progressive a legislation as the mediation bill. Also, the settlement agreement under the 12A of the Commercial Codes Act, the enforceability is like an arbitral award. My question is, when all other mediated settlement agreements are enforceable as a judgment or decree of the court, it would be appropriate that even the commercial disputes the settlement agreement should be enforced as a judgment or decree and not as an arbitral award, especially when the users of commercial mediation are very particular about the enforcement. So this is one area which we need to look at. Next, the mediation bill still continues to bear some flavors of arbitration. The pre-litigation mandatory mediation in commercial disputes, the settlement agreement being equivalent to an arbitral award, is a flavor of arbitration. Similarly, the requirement that settlement agreements have to be registered with an authority is similar to the depository that is required under the Arbitration Act. Yes, the Arbitration Act, the award is by a third-party arbitrator, whereas in mediation, it is by the parties themselves. It is self-determination. Confidentiality is very important. And when you require such a settlement agreement to be registered, that can prejudice the use of mediation by some users to whom confidentiality is important. The third flavor of arbitration, I would say, is the Mediation Council of India, where there is no compulsory requirement for a mediator to be a chairperson or a full-time member, because ADR professional can also be an arbitrator. Only a mediator with experience, with knowledge of mediation and experience of mediation will be able to understand how mediation can be used, how mediation can be promoted. This Mediation Council of India is going to be framing the rules, is going to be framing the code of conduct. This requires a deeper understanding of the nuances of mediation. So our bill continues to have some flavors of arbitration, which needs to be worked with. Next, the first schedule, cases not fit for mediation. As an experienced mediator, I can tell you that there are 5 kinds of cases that cannot be mediated. And those are those that require statutory interpretation for resolution, constitutional interpretation for resolution, those that require a policy to be free, a criminal non-compoundable offense, and lastly, when one of the parties is not competent to take a decision, because mediation is based on decision making. If one of the parties is not competent to take a decision and the law has not provided how such a person should take a decision, then that case cannot be mediated. So it's only these 5 factors that really prevents cases being mediated. But as I see, first schedule, none of them fit into these 5 factors. Next point, provision of concern, international commercial mediation. This is a good provision. India has signed to the Singapore Convention. India will soon ratify, and we need to harmonize the provisions. The settlement agreement under the mediation bill is enforced as a decree of the court or a judgment of the court. Article 2 of the Singapore Convention says that any settlement agreement that can be enforced as a decree or judgment of the court, the convention is not applicable. It needs to be harmonized. Secondly, the grounds for challenge in the mediation bill is different from the grounds for challenge in the Singapore Convention. This has to be harmonized. So, although international commercial mediation is a good provision, in order to ratify, we need to harmonize. Next, community mediation. I believe this is an unnecessary distinction. Every dispute that can be mediated, our bill, in its definition, in its possibility of what a mediator is broad. All categories of civil disputes can be mediated with these broader definitions. The definition of community mediation in the bill is ambiguous. It requires a panel of 3 mediators. The settlement is not enforceable. When our bill has provided for a broad definition of mediation, we can appoint as many mediators as is required. We can design a mediation. Every mediation is designed by a skilled mediator. Whether it's an IP dispute, whether it's a matrimonial dispute, a commercial dispute, different categories, a mediator who applies his or her mind will skillfully design the process. Having a separate category for community mediation is unnecessary. We should bring it, and every dispute, whether community or commercial, should all be mediated under the main bill. And therefore, it gets the protection of the bill and the same level of ability to design and craft environmental disputes or any other kind of dispute is possible with the current provisions in our bill. Therefore, this is an unnecessary distinction.
Yeah, may I request you to, I mean, it's very interesting presentation, but may I request you to wind up in a minute or so, why? Because then time constraints are there.
This is my last, and I've finished. Thank you very much. It has been a wonderful opportunity.
Thank you so much, Madam Laila, for a very comprehensive, I will say, and a very systematic presentation. Like a teacher, I mean, tells in the class. So each and every word, I think, happens to be so simple and it must have been engraved in the mind of all the participants. Thank you very much for such a nice presentation. So moving ahead, may I now invite Dr. Rajiv Mani, Additional Secretary, Ministry of Law and Justice, Government of India, to present his views, please.
Thank you, Madam Usha Tandon. Madam, am I audible?
Yes, yes, yes.
Thank you, Madam. And first of all, my thanks to the Delhi University and the NCPC Committee of the Honorable Supreme Court and the Vice Chancellor of the Delhi University to have organized this third conference on mediation and invited the relevant stakeholders to discuss the various provisions of the bill. I take this opportunity to welcome Honorable Professor S.P. Singh Baghel, Honorable Minister of State for Law and Justice. And it is under his guidance that this bill has been actually drafted and moved in the Parliament. So, and it is wonderful to have him at this discussion because ultimately it is the guidance of the elders which guides us as to what provisions we should make and how to bring relief to the litigants. I welcome all the other participants to this meeting, Madam Laila Ollapally, Madam Uma Ranganathan, Mr. Asutosh Mishra, and other participants, including Mr. Bajpayee, who gave a wonderful elucidation of his aspect of the mediation bill. Madam, there may be some other participants whom I have not named, but I welcome them too. First of all, let me thank Professor S.P. Singh Baghel, Honorable MOS Law and Justice, for having agreed to grace this occasion and guide us in this endeavor of our discussion on the prospects of the mediation bill. Madam, first of all, while the initial impetus for the standalone law on mediation came from the MCPC Committee of the Honorable Supreme Court, thereafter, of course, it was a decision of the Government of India to examine the draft bill which had been submitted by the MCPC Committee, wherein we had very learned inputs from various stakeholders, including the present Justice P.S. Narasimha sir, who was then a senior advocate and a member of the MCPC committee, and we had been benefited by his guidance also. Thereafter, of course, the government under the leadership of Professor S.P. Singh Baghel and the Honorable Minister of Law and Justice, Shri we had discussed the bill thoroughly and then put up a draft for the government to consider. Based on that draft, the bill, Mediation Bill 2021 was introduced in the Rajya Sabha during the winter session 2021 of the Parliament. Now, Madam, as we know that the mediation bill, first of all, why the need for a mediation bill, that is something which is very important. So that would justify what prospects it has. Of course, while drafting the bill, we had discussions with various stakeholders, some of whom are actually present in this meeting also. So based on that feedback and what we tried to balance it out, because this is the first time, of course, there is other provisions in law wherein mediation is provided for, but we do not have a standalone law on mediation. the Commercial Courts Act 2015 made a first beginning with respect to giving an institutional shape to mediation proceedings by referring the commercial disputes to pre-institution mediation and settlement under Section 12A of the Commercial Courts Act. As Madam Laila Ollapally was also pointing out, now I think with the 9th schedule to the Mediation Bill 2021, we would be having the change in the Commercial Courts Act also, and the mediation which would be conducted under the Commercial Courts Act, its enforcement and subsequent action once the parties have agreed to that settlement would be as per the provisions of the Mediation Act, and it would not be treated as an award of the court as has been contemplated in the present bill, that is the Commercial Courts Act. So the bill makes a change with that regard, with that aspect also. There are certain main provisions which I think we need to discuss, and already it must have been flagged in the previous sessions also, and the present session also made a reference to it, particularly with regard to promotion of institutional mediation. I mean, that was the basic concept which has been guiding, which has been the guiding factor for us, because we want that the adversarial system of adjudication has not been able to deliver the relief which the stakeholders and which the citizens expected from it due to variety of factors. That is, of course, a subject of a separate discussion. But to provide ease of living for the citizen, ease of living for the litigant, and promote ease of doing business in the country, it was imperative that new measures should be thought of and implemented. As a part of that endeavor and to reduce the burden on the courts, because already there are more than 4 crore cases which are pending in the various district courts, about 70,000 cases are pending in the Honorable Supreme Court, and nearly more than 58 lakh cases in the various high courts. So it was, time that new and innovative, impetus is given to the other modes of ADR. Of course, arbitration is the main, main weapon of, I should not say main takeaway for the promotion of ADR. And the Arbitration and Conciliation Act 1996, which was initiated and had promised great hopes, and to extent the arbitration has taken off, but the conciliation which was provided under the same act, under Part 3 of the law, somehow it could not get the same traction. And it was, of course, a very simple law, very beneficial for the parties, but for various reasons, I think it has not been able to take off. And now, one of the important changes which the present mediation bill makes, and which we need to emphasize, is that conciliation has now been subsumed in the concept of mediation. So henceforth, once the bill becomes an act and the law is enacted, I think henceforth the conciliation would also be, get an impetus in the form of mediation. And that is something which we have, permitted even the government to frame its own guidelines under the, there's a provision in the bill to that effect that the government can make provisions for its own disputes being resolved through any scheme, of course, which may be akin to a conciliation scheme, which is working very successfully presently in some of the institutions like NHAI, MSME Act, and some other acts. But coming to the main point which I wanted to emphasize was the mandatory pre-litigation mediation. Now, this is something, madam, which, as we all know, that we have to get a feel of the concept of mediation. Mediation is, of course, a skill which one needs to ingrain. It is not something, it may be something which may be very natural for some persons to act as a mediator, but for some others, they need to be trained and be skilled, and the hours of experience which they gain as a mediator would definitely help them in their discharge of duties as a mediator and bringing the actual effects of this bill to the parties and helping in the reduction of litigation and unburdening of the courts. So that was the primary aspect that forced us to actually, which made us think that we should go in for compulsory pre-litigation mediation. But what we have made is that the exercise of mediation has not been made compulsory. And once the party feels that, yes, it is not, the issue cannot be resolved through mediation, or it is not conducive to the given facts and circumstances of the case, it can opt out after 2 sittings of the mediation. So another aspect which was highlighted in this aspect is regarding the lack of trained manpower, because institutional mediation, if we are promoting, it is directly linked to the availability of the trained manpower which we have as mediators. Luckily, as per the data which we have from the National Legal Services Authorities Act, the latest data which was there, which we saw available till November last year, we had quite a substantial number of mediators present in throughout the various jurisdictions of the various high courts, and there are more than 5,000 judicial officers who are trained as mediators. Then, of course, there are lawyer mediators who are nearly 8,700 and more. So the presence of mediators, that is to say trained mediators, is already there in the country, and it is now upon the institutions as to how they come up. This opportunity has been given to them by the law to rise to the occasion, frame good rules, frame good institutions, attract people to mediation, and have trained mediators, so that the benefits of mediation which we contemplate, which the preamble states, which is the objective of the bill, actually permeates to the stakeholders, to the last person in the queue. So that is the actually which we had that noble motive at the back of our minds, and as per the guidance which we received from the Honorable Minister, sir, that we have moved this bill in the Parliament. Madam Laila Ollapally has also highlighted certain aspects of the bill, while she has broadly been in agreement and welcomed the suggestions which have been and the provisions which have been made in the bill. She had certain suggestions also. I think now, since the bill is in the purview of the Parliamentary Standing Committee of Law and Justice Personnel, and the committee is presently examining the bill, we will certainly be benefited to a great extent by the report which we are eagerly looking forward to from the Parliamentary Standing Committee for considering it and bringing any more beneficial provisions and making the act more potent in its effect and achieving its objective. Given that scenario, madam, I think it is now, because since we have been the persons who have actually drafted the bill, in the extent it is available in the public domain right now, it is for the other persons to scrutinize, to give suggestions, and to have a feedback from them as to what suggestions they may be given, which are practicable and which we can implement for the betterment of the bill, as well as for the betterment of the parties who are going to take recourse to it. Community mediation, in fact, has been a novel initiative of this bill, which makes a specific provision for it to begin with, because as we see in our daily lives, a lot of situations get out of hand due to maybe some dispute between neighbors, between involving petty matters such as parking or use of any other premises, and even in villages for that matter. So those disputes which have the potential of impacting the law and order of a country, or the law and order of a region or a place, or harming the peace and tranquility, we thought, let us have a independent panel of mediators who are persons of public standing and integrity in the community and in this said area, who can actually intervene and let the dispute which is now emerging between two sets of people be not drawn out as a full-blown litigation. So that was the intention behind bringing this provision of community mediation. There are certain other beneficial provisions also, and which of course you must have discussed it, but given the constraint of time, I may not be able to actually reach out to all of them, and the threadbare discussion on the various provisions of bill would be of course beneficial, which may have a closed environment. Of course, given that now the bill is there in the Parliamentary Standing Committee, so I will not take much time. I just wanted to emphasize the intention of the government to reduce litigation, to give benefit to the benefit to the stakeholders, to the parties, and promote a ease of doing business, and give traction to the available modes of ADR, mediation being one of them, so that its full benefits can be utilized by the public. That was the objective with which this bill has been brought forward, and now it is up to the Parliament to take a call upon the various provisions of the bill. Thank you, madam, once again for giving me this opportunity, and I thank you and all the other persons who made this conference possible. Thanks to all of them. Thank you, madam.
Yeah, thank you, Dr. Mani, for the wonderful presentation. I mean, coming directly from the drafters about the features of this particular bill, extremely, beneficial for the participants. Now, after hearing these speakers, I feel that there should be a full-fledged conference, not one session, full-fledged conference on the mediation bill, wherein we can really, be benefited from we can again invite the speakers to benefit us again. So thank you very much for such an insightful presentation, telling us the origin, the development of this bill, and what is exactly behind it, the main purpose or the objective of this of the government. And also, it was interesting to listen you, with which I completely agree that even though we are having Arbitration and Conciliation Act, somehow arbitration has flourished, but conciliation could not get that much attention. But again, I will see it. I have not seen it so deeply. So to what extent, this particular bill is impacting that? Why? Because you said that now conciliation is converted into the mediation. So there are the schedules which are impacting the other provisions. It is mentioned whether one is overridden or not. I don't know to what extent these conciliation provisions of 1996 Act have been dealt with by this particular bill. But yes, of course, so many, whatever you have covered is very useful for us to understand. So this is what I say, that one thing is what we learn from reading the provisions, and the other thing is that we learn from the persons who are behind it. So in that particular sense, thank you very much for coming and enlightening us. So moving forward, and now let me invite our another speaker, Ms. Uma Ramanathan, who is moderator and trustee of Foundation for Comprehensive Dispute Resolution, to enlighten us on some of the aspects which she believes are important in this session. Over to you, Ms. Ramanathan.
Thank you, Dr. It's always a difficulty to talk at the end of the day, and after such speakers who have been part of the framing of this bill and who have really gone through it threadbare and have pointed out what are the benefits and how certain wordings had been done and how they had thought about it. Coming from the point of an outsider, it's easy to be a critic. It's difficult to be creative. I know that. And all the hard work was done by them, and it's easy for me to deconstruct and say, oh, these are the problems. But then looking at the act, because today we are looking at something which is going to help us to make mediation be known as a profession, to establish the integrity of the process, to make it workable, to make it acceptable. So when Justice Banod said that interest threaten principles, I was struck by that statement. Now, what were the interests in drafting this bill? The interest was to have a regulatory force, was to see that institutional mediation could come up. We had an appropriate dispute resolution system which would help parties. But when we were looking just at the interests, I'm wondering whether we have forgotten the principles. Because ultimately, what is mediation about? Mediation is about, as Laila was saying, it is about self-determination, it's about confidentiality, it's about volition. So when we look at that, how has that been addressed here? When I was looking at commenting on the mediation bill, and I was trying to see whether there has been any discussion on in other jurisdictions also, I found that Ms. Alexander had a very poignant statement to make. She says, when we think of a regulation for mediation, what she calls it as a diversity consistency dilemma. She says, this is a diversity consistency because it's a very flexible process, and we are trying to make it a process which would be acceptable to everyone, so there must be some sort of a consistency. So she says, in this dilemma, it refers to tensions between two motivations. One is the diversity in practice through flexibility and the innovation. That is, we know that mediation is a very creative process. And on the other hand, to establish a consistent and reliable measure of quality of mediation. So, what are we doing here? The earlier session was about cross-border mediation, where I'm grateful to Dr. Rajput, who was stressing on culture, on confidence, on credibility, and Justice Benoth also mentioned about communication. So all these are part of the structures or the pillars that support mediation. Now, looking at the bill, how much of it is it enhancing the quality of mediation? Is it making the process acceptable as a legitimate process? My difficulty, I will just, because of the paucity of time, I will just refer to certain difficulties I have, because I know how much thought must have gone into drafting the bill and how effective it is. Because the earlier speakers have spoken about it, I will just talk about my difficulties in the bill. Of course, the earlier session was about cross-border mediation. So is that, as Justice Benoth also mentioned, it is not just about commercial mediation, it is about custody issues, about environmental issues, it is about so many things. So have we given a thought about that? Because when international mediation or cross-border mediation is referred to, is there a clarity on what is the kind of qualification?
Excuse ma'am, Honorable Minister sir have to move somewhere for some urgent issue. We have to invite him as a chair, as a speaker.
Would you like to do that now?
Yeah, Usha ma'am, Honorable Minister sir have to go somewhere on urgent basis.
Ms. Ramanathan, I hope you will,
It's okay.
you should incorporate.
Yeah,
So, yes, let us move on. Honorable Professor S.P. Singh Baghelji, you're most welcome to chair this particular session. You have heard some of the speakers, and just now we have come to know from Dr. Mani that you are the person actually who has been behind this bill in the drafting and taking all the pains in introducing it and seeing that it has reached to this particular stage. So, as a really creator of this particular bill, I think we will be highly enlightened with your address on this. So please, sir, over to you.
Third International Conference on Mediation Bill and its Prospects पर जो आज ये सेमिनार हो रही है, इसमें पधारे मेरे ख्याल से ब्रजेश पाठक जी को रहना था, जो यूपी के मेरे साथ लॉ मिनिस्टर थे और डिप्टी सीएम है, शायद दिखाई नहीं पड़ रहे हैं. ऑनरेबल मिस्टर जस्टिस कानन, फॉर्मर जज पंजाब एंड हरियाणा हाई कोर्ट, डॉक्टर राजीव मनी, एडिशनल सेक्रेटरी डिपार्टमेंट ऑफ लीगल अफेयर्स, जिनका इस बिल के ड्राफ्टिंग में बहुत बड़ा योगदान है. मैडम लैला, श्री सुजीत कुमार जी बनर्जी, प्रोफेसर उषा टंडन जी, उमा जी, डिस्टिंग्विश्ड गेस्ट ऑफ लॉ फैकल्टीज, लॉ स्टूडेंट्स, लेडीज एंड जेंटलमैन. मैं बहुत मणि जी के, उमा जी के और मैडम लैला के विचार सुन रहा था मीडिएशन बिल के ऊपर, और ऐसा लगा कि ये आपके विचारों को सुन करके कि ये बहुत ही रेलिवेंट है, प्रासंगिक है, देश के बहुत काम आएगा. लेकिन एक बड़ी घटना हो गई है मेरी कॉन्स्टिट्यूंसी में, जिसकी वजह से मुझे बीच में जाना पड़ रहा है, इसलिए मैं भी लंबी बात नहीं कहूँगा. मैं आपका धन्यवाद देना चाहूँगा कि मुझे मीडिएशन बिल और उसकी संभावित भूमिका पर इस विचार मंथन सत्र में भाग लेकर बहुत खुशी हो रही है कि सुप्रीम कोर्ट ऑफ इंडिया की मीडिएशन एंड कॉन्सिलिएशन प्रोजेक्ट कमेटी, जो MCPC द्वारा मीडिएशन पर एक स्वतंत्र कानून लाए जाने के लिए जो वास्तव में प्रयास है, वो सराहनीय है. मैं इस अवसर पर दिल्ली विश्वविद्यालय के लॉ फैकल्टी, दिल्ली स्कूल ऑफ पब्लिक पॉलिसी एंड गवर्नेंस को इस कार्यक्रम के आयोजन के लिए बधाई देना चाहूँगा. मेरा सौभाग्य है कि दिसंबर के महीने में 21 दिसंबर 2021 को राज्यसभा में मीडिएशन विधेयक को इंट्रोड्यूस कराने का ये ऐतिहासिक कदम था. मुझे राज्यसभा में अवसर मिला था. इस विधेयक को संसद में पेश करने का मुझे सौभाग्य प्राप्त हुआ. इस विधेयक किसी विवाद के पक्षकारों को एक ऐसा प्रभावशाली समाधान प्रदान करने के लिए सरकार के प्रयास को आगे बढ़ाने के लिए लाया गया है, जो मुकदमेबाजी से प्राप्त नहीं हो सकता है. मैं हमेशा कहता हूं कि मध्यस्थता होती है और मध्यस्थता के बड़े परिणाम आते हैं. जब कौरव और पांडवों के बीच युद्ध बिल्कुल जो है टाला नहीं जा रहा था, उस समय स्वयं भगवान श्री कृष्ण इस प्रकार के प्रस्ताव को लेकर के कौरवों के पास गए थे और बदले में केवल 5 गांव मांगे थे. जिनको ना मिलने पर एक महाभारत हुआ और जिसमें सभी सेनाएं मरी हैं, कुछ लोग केवल बचे और बस उसका एक बड़ा खामियाजा भुगतना पड़ा पांडवों को भी और कौरवों को। काश कृष्ण भगवान ने जो मध्यस्थता की थी उसको मान लेते तो एक बड़े महाभारत युद्ध से देश वंचित रहता और तमाम बच्चे यतीम नहीं होते। मुझे बार बार फोन आ रहे हैं जहाँ मुझे जाना है, एक मर्डर हो गया है तो मुझे वहाँ जाना पड़ेगा। मैं इस अवसर पर केवल आपका धन्यवाद देना चाहूंगा और मैं माफी चाहूंगा कि मैडम उमा बहुत बढ़िया बातें जब कर रही थी और मैं उनकी बहुत अच्छी जानकारी जो दे रही थी उससे वंचित रह गया। तो राजनीति में यही होता है, अचानक जाना पड़ता है। लेकिन आज का समय ये मैंने आपके लिए 2 घंटे रखा था कि मैं अपना ज्ञान वर्धन करूंगा और इस अवसर पर अब मैं बस धन्यवाद देना चाहूंगा क्योंकि मुझे जाना होगा। मैं सुप्रीम कोर्ट की MCPC दिल्ली यूनिवर्सिटी की लॉ फैकल्टी, दिल्ली स्कूल ऑफ पब्लिक पॉलिसी एंड गवर्नेंस को अपनी शुभकामनाएं देता हूँ। मुझे विश्वास है कि यहाँ जो चर्चाएं हो रही हैं वो तार्किक निष्कर्ष पर ले जाएंगे ताकि हितधारकों को मीडिएशन की बारीकियों को अच्छी तरह से समझने का मौका मिलेगा। और मेरा निजी अनुभव है कि मैं ये देख रहा हूँ कि प्रत्येक गांव से हर थाने में मुकदमे लिखे जाते हैं। यूपी के संदर्भ में मैं देखता हूँ तो 2000-3000 तक क्राइम पहुंचता है प्रत्येक थाने का। लेकिन मैं निजी तौर से जब गांव में पूछता हूँ कि धारा 323, 504, 506, 324, 325, 147, 47, 49, 504, 506, 457 इन धाराओं में जो मुकदमे पंजीकृत हुए हैं, क्या आपके गांव में कोई व्यक्ति सजा याफ्ता है जिसको 3 साल की, 4 साल की, 5 साल की, 6 साल की, 7 साल की? एक बार फिर मैं धाराएं रिपीट करूं कि जो गांव में झगड़े होते हैं जैसे धारा 147, 48, 49, 323 IPC, 504 IPC, 506 IPC और 324 बाई शार्प एज ऑब्जेक्ट, 323 हार्ट एंड ब्रेन ऑब्जेक्ट या 325 फ्रैक्चर या 326 अंग भंग होना या 307 में अटेम्प्ट टू मर्डर या 308 इंजरीज वाइटल पार्ट ऑफ द बॉडी पर। तो मैं ये देखता हूँ कि गांव में लोग तब तक जेल में रहते हैं जब तक उनकी बेल नहीं होती है। लेकिन मैंने किसी भी गांव में आज तक जितनी धाराओं का मैं उल्लेख कर रहा हूँ इनमें किसी धाराओं में सजा पाते हुए नहीं देखा। तो क्या होता है, बाद में समझौते हो जाते हैं। शुरू में गुस्से में मुकदमे लिखाएंगे लेकिन बाद में तारीखों के दौरान हमेशा समझौते हो जाते हैं। लेकिन उनका ये समझौता तब होता है, माफ करना, एज ए लॉ मिनिस्टर मेरे को नहीं कहना चाहिए, तो तमाम सारा पैसा उनको पुलिस को फाइनल रिपोर्ट लगाने के लिए, चार्जशीट लगाने के लिए, नाम निकालने के लिए, नाम जोड़ने के लिए, मेडिकल इंजरीज बनवाने के लिए, नाम बनवाई देने के लिए, इन तमाम चीजों में जब वो बर्बाद हो जाते हैं तब जाकर के ये आपका मीडिएशन बिल अब आ रहा है। लेकिन गाँव के पंच, सरपंच, प्रधान, जाति नेता जाकर के बैठ के समझौता कराते हैं। तो समझौते का रास्ता हमेशा ठीक है। मैं हमेशा कहता हूँ कि युद्ध का रास्ता ठीक नहीं है, बुद्ध का रास्ता हमेशा ठीक रहता है। तो ये बहुत धन्यवाद देना चाहूंगा, हमारे विभाग ने इसकी ड्राफ्टिंग की है, सुप्रीम कोर्ट की गाइडलाइंस रही हैं और इसको स्टैंडिंग कमेटी में रेफर हो गया है और वहां से भी तमाम लर्नेड MPs इसके बारे में अच्छे सुझाव देंगे और एक जो हम मीडिएशन बिल के बारे में एक जो शेप लेंगे स्टैंडिंग कमेटी के बाद, आप लोगों के ये एक्सपीरियंस के बाद और 1-2 और ऐसी सेमिनार हो उसके बाद हम कुछ और अच्छा कर सकें जिससे स्टेक होल्डर्स को फायदा हो सके। मैं हृदय से माफी मांगना चाहूंगा, मुझे कॉन्स्टिट्यूंसी में जाना है लेकिन बहुत अच्छे जो विधि विशेषज्ञ लोग हैं वही इस पे सोता है और इस पे स्पीच भी वही लोग दे रहे हैं जिनको कानून का बहुत अच्छा ज्ञान है। मैं माफी चाहूंगा कि अभी कुछ 2-3 स्पीकर्स जिनके लाभप्रद सूचनाओं से मैं अपना ज्ञान वर्धन करता मैं वंचित रह रहा हूँ। मैं इस कॉन्फ्रेंस की शुभकामनाएं के लिए शुभकामनाएं बधाई देता हूँ कि ये जो विचार मंथन हो रहा है इससे जरूर समुद्र मंथन नहीं, ये विचार मंथन हो रहा है। इस विचार मंथन में जरूर कोई ना कोई अमृत निकलेगा जो देश के काम आएगा। थैंक यू वेरी मच।
बहुत बहुत शुक्रिया सर, आपने इतने बिजी शेड्यूल में और ऐसी इंसिडेंट्स जो आपने बताया आपकी कॉन्स्टिट्यूंसी में हो रहे हैं उसके बावजूद जो है हमारे प्रोग्राम में आप जुड़े और आपने जो है हमें बहुत ही सरल भाषा में बहुत ही अच्छे एग्जाम्पल हमारे जो है हिस्ट्री में से देके जो है इस बात का महत्व हमें समझाया, मीडिएशन का महत्व समझाया, उसके लिए आपका बहुत बहुत शुक्रिया सर। हम अच्छी तरह से समझते हैं कि आपका जीवन कितना व्यस्त होगा इन सब जिम्मेदारियों की वजह से। बहुत बहुत शुक्रिया सर आने के लिए, टाइम निकालने के लिए। थैंक यू सर। Yes, I think Mr. Ramanathan, you may continue, and I hope you will appreciate because that was really energetic on his part. And I will request you to take 2-3 minutes. Why? Because then we are having the valedictory session also.
I know.
Yeah. So yeah.
I didn't want to go through it section by section, but broadly, what I wanted to say is that I just want us to reflect, because mediation itself is a reflective practice. I just want us to reflect through every part of this bill and to see whether we are, the lens through which we are seeing. Are we seeing it only through the lens of enforcement? Are we looking at only commercial disputes? Are we looking at it as a practice that is going to benefit all stakeholders broadly? Now, when we talk about any regulation, we are talking about a code of conduct, about effective practices, about standards. So, is there enough provision for accreditation, for licensing, for mentoring and monitoring the practices? Because we are talking about institutional mediation. Now, earlier there was a talk about, I think Dr. Mani said about how many mediators are available. I have a problem with that, because in our system, any advocate who has a number of years of experience has been trained as a mediator. Any mediator who has done 50 successful mediations has been trained as a trainer. And often we have found that there are complaints both about the mediator and about the trainer. So is there a mentoring system, is there a monitoring system, or is there an evaluating system? Are the mediators who are there updating themselves? Because the act, the bill itself says about esteemed persons. There is a lot of fluidity in those definitions. When we talk about esteemed persons or exceptional circumstances where the court can grant interim relief, these are causes for concern, because we know how it can be misused. And especially when we are talking about community mediation and online mediation, are we having enough standards, or are we putting in enough regulations to see that it is governed properly? I just want to conclude with a thought that we would have to reflect on. What is a statute ultimately? A statute is the will of the parliament. It's an intention of the parliament to for a particular reason, and it is this statute which is going to be interpreted by the courts of law. It's the statute which gives judicial power for interpretation, either for the performance of a particular act or for regulating that particular act. A statute is necessary. So, are we conscious of the fact that when we are bringing a bill to regulate mediation, do we have enough provisions to ensure an effective practice? Because we are not talking about enforcement of a right here. We are talking about a practice which is going to be a profession, which is going to be more satisfying for all the stakeholders. Generally, the talk is about how the courts are overloaded. And so mediation is going to be the process which would help to offload all the load from the courts. And that mediation is a win-win situation, both of which I have a problem with, because I think it is ultimately the parties' decision, because we talk about self-determination. It is for the parties to decide what is suitable for them. It is for the parties to accept a particular situation and come to an agreement. It's at that stage when we go into enforcement. If we are going to talk about it from the point of Singapore Convention or about enforceability, we are not addressing the grassroots level at all. When Professor Bagal was saying about all these thanes and how complaints go to the police, that is a reality today. Most of the people who are caught in a conflict want to get immediate redress and they go to a police station. So are we addressing all those situations? Are we making people aware that there is an alternative, and that it is for them to decide what is good for them? Giving them that courage, giving them that ability, because it talks about registration, it talks about legal services. There are all those areas which have to be addressed. And as I said, it is very easy to critique and it is very difficult to create something. And of course, with due respect, I have to say it has been a great attempt, and I'm sure a lot of great minds have gone into it. And as a person who is looking at it objectively, I just stated these few concerns of mine. And as Professor Tandon was saying, we need to have a 1 or 2 day conference on this to discuss it section by section. And maybe that would also not be enough. But I must thank you for this opportunity to express
Thank you so much. Thank you so much for such a wonderful your presentation. Actually, the dignitaries of the valedictory session have also already joined. So I will say it's a very fruitful session. Why? Because from creator to critiques, from beneficial provisions to the provisions for the concern, all these things in such a short period of time, I think, have been at least those points have been put in the mind of the audience. So thank you very much for all the distinguished speakers for your time and enlightening the audience. Thank you very much. So with this, I think we can wind up this session, Dr. Ashutosh, so that we can start our validity session on time. Thank you.